Next call 127-259 in the interest of AK, a minor child.
May it please court, Richard Klein on behalf of the appellant of AL, who is the mother in this case. KSA 38.
Mr. Klein, I just want to make sure,
Oh. I apologize.
No, that's okay.
Could I have 4 minutes?
Certainly.
Rebuttal time, please.
Yes, 4 minutes granted.
Thank you. KSA 38-2248F allows for a proffer of evidence to terminate parental rights in a child in need of care case. And I'll help the students out to just briefly explain what a proffer is. A proffer is when an attorney states the evidence that they think they could present at trial to a court, as opposed to putting witnesses on a stand in an evidentiary hearing. In here, I have two arguments in this case. One is that the district court did not follow the proffer statute, did not follow the proper procedures in allowing for proffer to occur. And two, that the statute itself is unconstitutional. And this case is yet another case in the state of Kansas that shows the pitfalls of having a proffer of evidence to terminate a fundamental constitutional right to parent children.
And I want to get into the your constitutional argument, but let's go back to what the district court did here. And why is it in violation of the statute as it's written? And how do you interpret, unless they appear under the statute, unless they appear by counsel and have instructed counsel to object? You took the position early on that mother must want me to object because she wants to keep the kids, and that was at an earlier proceeding. But at the proceeding in question here, substitute counsel said, no, I have not talked to mother, right?
Yes.
And I have not been instructed to object. So how is that? Does your initial invoking the statute that the mother told me to, is that for every subsequent proceeding, or is it for every proceeding that there must be a statement from the mother?
Well, that's one of the questions, obviously, that's involved here. So I think we probably need to go through some of the facts quickly, and I can fill in. I think this is in the record, but I'll fill in some of the practical things that occur in child native care cases that may be helpful. So on July 25th, 2023, there was a proffer trial that had been set. So that setting would be a 30-minute setting. And that was set before at another hearing because the mother had not had a lot of contact with the foster care provider, KVC. So nobody thought the mother would come to that trial, or nobody thought that the mother would have contact with her attorney and instruct the attorney to object. And that's done routinely in these cases, and it helps the court's calendar. I think we'd all agree that that it's appropriate to do things that'll help a court's docket. And so on July 25th, counsel came to court and said, now I have talked to my client. She's been back in contact with KVC. And at this point, and he didn't say any magic words. He didn't say my client told me to object, but he did say words that in effect said, we can't have a proffer trial. And the district court took that as an objection to the proffer trial because the district court at that point set a trial setting, a full day setting for trial on November 1st, 2023. There was a pretrial conference on October 4th. And at that pretrial conference, which was done by Zoom, counsel for the mother said, I haven't had any contact with my client. So at this point, I don't think I'm going to object
To proceeding by.
to proceeding by proffer.
Correct.
And then on November 1st, mother's counsel sent a substitute counsel for him who went to trial and said, we don't object to a proffer. Now, I think it's fairly clear that the mother objected to a proffer. That was clear from July 25th. Nobody had contact with the mother after July 25th. And
Counsel, let
that
me ask you a
objection should
question.
stand.
So where substitute counsel went and said no objection or whatever, prior to that, tell me if I'm correct, that counsel said, we want a continuance. Didn't he
Yes.
ask? He asked for a continuance. So he didn't just go in and say, oh, so could that request for continuance kind of cement, look, she's objected to a proffer, so we're not ready to go right now. I haven't talked to my client. And so we need a continuance, right?
Potentially, yes. But so the question is, and I think that obviously the attorneys here viewed it because the state talked to mother's counsel before the trial setting. So obviously the attorneys viewed it as there needed to be another objection and potentially another objection. And I just don't see how the statute says that. The mother clearly objected. That was done on July 25th.
And so that objection is
A standing objection?
a standing objection to the whole procedure, even in spite of counsel saying, I haven't talked to the mother, we'll go ahead and proceed.
If the mother told counsel to object and never told counsel not to object, and counsel said, I've not talked to my client. So obviously the mother did not tell counsel not to object, then yes, that objection should stand.
So there needs to
And-
be some indication that mother has changed her mind, not just that she's absent.
I think clearly. And again, as I briefed it, and this is relatively sarcastic, I think that I think a parent could, during the first temporary custody hearing, a parent could say, if they knew what the statute says, could say, you need to object to a proffer no matter what throughout the case. And if you never talk to that parent again, I think that attorney would have to do that. And again, the facts in this case just show the pitfalls of trying to move forward by proffering evidence instead of taking the time to put somebody on a witness stand and ask them questions.
Okay, before moving on to your constitutional argument, which I know we want to hear, and that's consistent with, the statute is actually like a default stipulation statute, right? Which would require, that's, it ended up having this subsection in 2008, they ended up ferreting it out and putting it in a different subsection. But this all has to do with this part of this particular statute has to do with stipulations, when you can proceed by stipulations from the parent, as well as a default, an actual default of not showing up, right? And so,
Well, I think there's an obvious difference in default and a default judgment. The Court of Appeals.
right, default, okay, I'm
But-
sorry.
But frankly, that's been a problem in the state also. Since 2019, the Court of Appeals has reversed 3 default judgments in child in need of care termination cases. It's a rush to judgment in these cases. We're trying to get through things too quickly. We're setting aside a parent's fundamental right to raise a child.
Isn't it more
So-
about, look, you come in like when you're doing the initial adjudication, you can either have an evidentiary hearing, or you can, do a no contest. I'm not gonna, but you actually have an affirmative action by the parent before, infringing on this fundamental right. And here we don't have any affirmative action, whether it's, the only affirmative action we have was in the previous one saying, I don't want to proceed by proffer.
Yes, I'd agree with that.
All right, I guess now you should get to.
Yeah, go ahead and
the
jump to
meat
your-
of the-
Okay, so
That's an important
that
consideration.
was a 7, not a 1.
And basically,
Oh.
let's frame it as, basically, it's your position that a proffer can never, ever meet a clear and convincing evidence standard. And why don't you start there and tell us why that's so?
So if we look at the Matthews balancing test, I think we'd all agree that a parent has a fundamental right as a start point. The state has an interest in this as well. So those are two parts of the balancing test. And the real issue is there a risk of deprivation of interest, or is there value in putting in substitute safeguards? And I'm gonna give you a couple quick examples here and I'll start with this. In the facts of a facts and determination trial are hardly ever at issue. I mean, normally the facts are the facts, but there are times, and the conclusions based on those facts are often what's at issue. But there are times where facts are not exactly the facts. So I'll give you a couple examples. So let's say the state proffers the mother, we're 2 years into the case and the mother doesn't have a house to live in. Okay, and that's a fact. So let's say we had a evidentiary hearing and the state asked a social worker, does the mother have a house to live in? No, she doesn't. And then cross-examination goes like this. The mother had a house for 10 years that she lived in, didn't she? Yes. And she paid off the mortgage in that house, didn't she? Yes. And 2 weeks ago, it got hit by lightning and burned down, right? Yes. And it's a huge difference there, right? In those facts. It's gigantic. And let's do another quick example. So
Well, let's just move to the proffer in this case. We have a proffer in this case.
yes,
How is it not a reliable, or how does that not meet a clear and convincing standard? And is it simply because of the process used?
yes, that's my argument. There's no argument that the mother here did a great job. I mean, she didn't. She wasn't in contact with KVC was the primary issue. And she didn't do a lot.
So,
But I don't.
I'm sorry, but it seems to me there's two ways to read this statute potentially. One, the proffer is evidence. The statute's saying that without objection, the court may consider a proffer as evidence. Or alternatively, the statute could be saying, if there's no objection to trial by proffer, that actual evidence is not required. Which of those two things do you think this statute is saying?
In practice, it's the second. I will acknowledge that if you look at the Court of Appeals opinions, it's the first. But I still think that there have been.
Well, how are we gonna, that's a crucial question, it seems to me. How are we going to resolve that question?
At a minimum, I think that the district courts in the state and the Court of Appeals need some guidance on that.
Well, let me ask the constitutional question. Is it constitutionally permissible as a rule of evidence for a state legislature to say proffers count as evidence in certain circumstances?
If you're asking me, no, absolutely not.
Why not?
It's shocking to.
Well, you might think it's bad policy, but why is it unconstitutional? As a rule of evidence, I mean, typically we think of rules of evidence as the legislature and courts have wide latitude to decide what counts and what doesn't count.
As I briefed, you have the proffer statute, and then the very next section in the code, the next sentence in the code says you must have clear and convincing evidence.
Right, but if the proffer is evidence here, as Justice Rosen pointed out, it's a good proffer.
This one was, you're right. This was a good proffer.
So is it evidence? That's my question. And I know your argument is it's not evidence, but it seems like, at least as you pointed out, the way the Court of Appeals has interpreted the statute, what they've essentially said is, look, this statute says that proffers count as evidence when they're not objected to.
I think it's impossible to put evidence on from one side without having either.
I get all the policy reasons why this is terrible. I'm trying to figure out what the statute's actually saying, and if it says what the Court of Appeals interprets it to be saying, why is that unconstitutional?
Again, I think if we look at the Matthews balancing test and we consider fundamental fairness, there is no way.
Fundamental fairness or due process? I mean, doesn't it
It's-
depend? You know, is it particularly here because of the right at stake as opposed to a proffer in a trial, you know, about something else? I mean, is it
It's,
it-
it's,
a
it's-
violation of the Constitution because of the fundamental right at stake in taking children
yes,
away?
yes, absolutely. To me, when you try and balance the three things that the Matthews test says, that you always have to come to the right to parent a child as trumping everything
Why
else.
doesn't the statute protect that? I mean, first, the parent has to not even appear. The parent's not there.
Right?
And second, the parent's attorney is given an opportunity to object, and it can only be used if those conditions are met. Why isn't that sufficient due process protection?
Again, I think that, and I'm going to say the same thing I just said. You're taking away a parent's children. How hard is it to put on evidence for 30 or 45 minutes?
But I think you're trying to suggest that it's the risk of an erroneous deprivation is what swings the due process analysis in your favor. And so there's something about the proffer process that renders it unreasonably unreliable.
Yes.
And to Justice Stiegel's point, that only happens once, I mean, they have a right to appear. They have a right to put on that evidence, but the statute only provides for this process when the parent doesn't appear and hasn't instructed to object to this procedure.
There's a
So
difference.
where's the risk of unreliable deprivation
First,
at
I'll
that
say,
point?
I'm sorry. First, I'll say there's a difference in the theoretical and the practical. Telling a parent to show up at a termination trial where they think they're inevitably going to lose is hard. And it's hard for the parent to do that. But almost all parents love their kids. Any parent who's involved in the case, they love their kids. And what you're asking them to do is show up at a termination trial and get beat up for a day about how bad a parent you are. Is what you're asking them to do. So, and again, so theoretically, yeah, sounds good. Practically, it's difficult for parents to do that. And it's not difficult for the state to put on evidence. It's just a little more time.
How much,
And-
you mentioned in your petition for review that we're talking a half hour, 45 minutes of time. Is that accurate? I mean, whenever we get these kinds of cases and we go a certain direction, what is the impact if we say, no, proffers can never satisfy clear and convincing? The state has to put on some evidence. What evidence, like in a typical case or even in this case, would be required?
I don't think it would take a whole lot longer than a proffer. A social worker gets on the stand and yes, and the state has to ask 10 questions. You know, when was the last time you talked to the mother? 6 months ago. How involved was she in the case? She wasn't. Did she complete any task on her reintegration plan? No. It's not that hard.
And is the point here that it just opens up the possibility for cross-examination?
Yes,
That's absent
yes.
otherwise. And so that's the heightened protection.
That's my argument. And I also think that anything that makes the state's job easier we should look at and be super suspect of it. It just, would it take a little more time on a court's calendar? Yes, and I do understand that is something we should all consider. I'll acknowledge that. We should consider a court's docket. But making life for the state easier, unheard of. So subject to any additional questions.
I don't see any. Thank you for your argument. Ms. Davies?
Thank you. Good morning. May it please the court. Plaintiff appellee, State of Kansas, appears by Assistant District Attorney Maria Davies. So I'm going to start with the statutory arguments, and then I'm going to move into the state's response to the constitutional arguments. Talking about the July objection, the state contends that mother's attorney's July objection to a trial by proffer, it was insufficient under the statute. It was insufficient under the plain language of KSA 38.
Is that because the council didn't specifically say mother instructed me to, and as opposed to she wants to keep the kids, so I'm going to ask for a trial to invoke the statute?
Yes,
is that
Justice.
is that your basis here?
Yes, Justice Rosen, that's the state's basis. He said, as such, Judge, I have to, as an advocate for my client at this juncture, object to the proffer trial and ask the court that we proceed more formally. So this does not establish that he objected at mother's direction. He's saying that he's objecting as an advocate. And I also want to point out that—
What do we do with the fact the court said, yes, okay, I'm going to go ahead and set it for an evidentiary hearing based upon the objection?
Justice Rosen, I believe that that would have been error. I don't think that under the statute, under the plain language, that both components were met. It was met that mother did not show up. However, it was not clear from the record that mother directed her attorney to object. However, Judge, even if this court does find that the July objection was sufficient, the state would argue that mother's two waivers in October and November were not sufficient. So mother, she did not appear at the October pretrial, and it's important to point out that she actually had notice of both the pretrial and the trial date because she did end up showing up late at the July hearing. Mother's attorney at the October trial, or at the October pretrial, said would raise no objection to a proffer as such. And then mother also did not appear at the November trial, and that's when the prosecutor told the court that he had been in contact with both mother's counsel and mother's substitute counsel, and there's not an objection to proffer. And then substitute counsel also chimed in and confirmed. He said, I have not been instructed to oppose a proffer. So the state's argument is that mother's lack of participation made it necessary for her to reach out and advise her attorney to object. At the October and the November hearings, both prongs then of the statute were not met because it's not clear that the mother directed her attorneys to object. There's also no authority that the objection at one hearing extends to all future hearings. The state would contend that if this court does find that the July objection was an objection, it was not contemporaneous in time. And so if you look at the plain language of the statute, it states, in evidentiary hearings for termination of parental rights under this code, the case may proceed by proffer as to the parties not present unless they appear by counsel and have instructed counsel to object. And the state would argue that the statute is implying that this is present tense unless they appear by counsel. And so it's clear that she did not appear at the October pretrial or at the November trial, and her counsel clearly stated on the record that they did not have the direction from her to object.
So the part about being present tense unless they appear by counsel, but then we're going to past tense and have instructed past tense counsel to object.
Yes, Justice Dandridge, I don't think that the state would necessarily pat on that the statute is present tense, but I would point out that even if it's not present tense, it says that counsel must have been directed to object to proceedings by proffer by the parent. And so I think if the court interprets it differently, it's clear that in October and November, there was nothing on the record that stated that mother said to either counsel that she wants to object to a proffer. And then I want to also go to the constitutional argument. The state would offer that mother's due process rights were not violated. She was given notice and she was given opportunity to be heard. As I mentioned earlier, she actually showed up at the July hearing, and that was when the court went through and picked times.
Yeah, she's given an opportunity to be heard, but can what is produced be for the state to meet the clear and convincing standard be a proffer? I mean, in your mind, what is a proffer? What is it a chapter 60 type of proffer? Is it a proffer that is typically used to preserve an issue for appeal? What in this instance or in this statute do you consider a proffer?
Justice Rosen, I consider that a proffer is a explanation of the evidence that the state and that the other parties would have put on if it proceeded to trial.
It's an explanation of the evidence. Is it evidence?
Justice Rosen, I believe that it would be. The court made numerous findings, and it's on the record under KSA 38-22 at 69. The district
It
court
found that there's clear and convincing evidence. What Judge Loudon found was based on the proffer. There wasn't really anything else that she found that there was clear and convincing evidence other than it was contained in the proffer.
right, and I would
Not
rate
subject to any kind of cross-examination, not subject to anything but a summary of what the evidence will be.
right, and I would address that in 2 points, Justice Rosen. The district court, it still was bound by the standard of clear and convincing evidence when moving forward on finding unfitness and foreseeability. Also, the court will see in the transcript from the district court that the judge asked the parties, does anyone else have anything to add? So mother substitute counsel could have added other comments if he wished. The GAL, she also chimed in and talked about how mother had a child months earlier that was born and taken into foster care in Missouri. So it's not just the state who has the stage and who gives all the facts about what it was that happened. The other parties at the hearing do have the opportunity to chime in.
So given all that, the deeper I got into this case, the more it struck me that the constitutional issues here are a bit of a red herring. I mean, I presume that nobody, including the state, thinks that the state can terminate parental rights without any evidence, right? That would be unconstitutional, right?
Correct, Justice Stegall. I'm going.
So that's not really being contested. The real question is what counts as evidence under this statute, right? And the difficulty I think we're all having is this statute appears to make a proffer evidence, but as you responded to Justice Rosen, I mean, the well-accepted and clear understanding of the word proffer is that it's not evidence. So what are we supposed to do with that?
Justice Stegall, I'm kind of looping back to the discussion that you had with Mr. Klein about default. I think that the proffer statute is very different than default because again, the parties, the district attorney and the GAL and the other parties, they can say what it was that would have been the evidence presented. I understand the court's point about what is evidence. I would also point out.
Well, I'm sorry to interrupt again, but I want to redirect a little bit. I want to do just some straight statutory analysis using our modes of interpretation and construction. And we always start with the plain language. So I want to ask, in your view, is this a plain language problem or is the statute ambiguous? And before you answer, I'll point out that the one sentence, it's one sentence long, talks about evidentiary hearings proceeding by proffer. Does that by itself create an ambiguity?
Justice Stiegel, I think looking at the plain language where it says in evidentiary hearings for termination of parental rights, I think looking at the plain language that suggests that a proffer would be considered evidentiary because it's taking place at the evidentiary hearing. That's how I interpret the statute.
So under this statute, when a state makes a proffer, they actually have presented evidence under your reading of the statute.
Yes.
And then
Justice-
my final follow-up question is there any constitutional problem with the legislature making a rule of evidence that says in certain circumstances, proffers count as evidence?
Justice Stiegel, I don't think that there is an issue because again, the mother, she has notice, she has means to object to this because she doesn't even need to show up. She can just tell her counsel, please object to a proffer on behalf of me. And then the mother's attorney can get in there, he can cross-examine witnesses, he can present his own evidence. I would point to, in this case, the district court also gave counsel deadlines for exhibit and witness lists, and that did not happen. Judge, in this case, he did not submit any witness or exhibit lists. And then finally, I think, again, it's important to point back that the district court, she didn't just have the state do the proffer. She asked other parties, was there something you'd like to add? So I think under the statute, how I read it is that the proffer is evidence because it's part of the evidentiary hearing.
Yet the first sentence of the state's proffer is, if we were to proceed to trial, basically it's as we are used to hearing in proffers, Judge, this is the evidence we would intend to present if we went to trial, not Judge, here's our evidence. I'm in essence with the prosecutor testifying. I don't know that the state's necessarily bound by that, but to me, it does kind of indicate that this isn't always seen, even by the state's attorneys that are presenting it as I am presenting evidence here. Is that practically, is that true? I mean, is it clear to those who are doing this process, the role of this hearing and this proffer?
Chief Justice Luker, I understand what the court is saying. I think if the court wants to view it as maybe a different type of evidence, it still would be constitutional because the mother, again, she had the safeguards, she could have shown up, she could have presented evidence. I think also the state has the interest in the procedure being used. I know that Mr. Klein talked about how he would estimate that if the parties were supposed to have a trial instead of a proffer, it would only be about 30 to 60 minutes. I think that these cases are very complex. And as the court went through, there were multiple different findings that were made about the mother's unfitness. And so it couldn't be that just one KBC worker or one DCF worker gets up there and is able to testify about knowledge about all of what happened in the case. For example, if a parent didn't have housing or didn't take UAs or didn't have transportation, it'd be likely that they would have to bring in someone who did the UAs or who tried to help the parent with housing or tried to help the parent with transportation. So I think the state has an interest in this process. And if the court wants to view it as a different type of evidence, I think that mother's due process rights were still protected because she had opportunity, notice, and she didn't even need to actually appear. Her attorney could have objected to a proffer on her behalf.
You keep talking about opportunity, notice and opportunity to be heard, which is procedural due process. My concern is more substantive due process, which is depriving her of her fundamental right to parent her children when the standard is clear and convincing evidence. And when you say, I could maybe say clear evidence, but when you're talking about convincing, don't you need to have the whole picture and cross-examination? How can, when my kids say, they give me a convincing argument and then I respond, or even, your colleague gets up and I'm like, wow, that's pretty convincing. And then you get up and I say, oh, now that I see that in context, that's not convincing. How can you find, when there's a, fundamental right to parent at stake, that something is convincing when you only hear one side?
Justice Standridge, I would loop back first to termination motions being filed. I think then that parents and the council, they'll see what it is that the state is expecting to put on evidence and expecting to either proffer or call witnesses.
Cross-examine a proffer.
I think, Justice Standridge, that the fact that the district court does not just ask the state what the proffer would be, the fact that the district court asks the other parties, is there something to add? I think the district court then can.
So
take that
if a
into
district court
consideration.
doesn't say that in the next case, it would be a different outcome?
I think that that could pose problems perhaps in a different case, depending on if the court were to find if the parent even had notice, if the parent did not explicitly object to a proffer, and then if the district court did not ask the other parties anything else to add, I think that that would be a much weaker case, Justice
Do
Standridge.
you
mean-
add to the mix here that it was substitute counsel that probably didn't even know the mother?
Justice Standridge, at first I was concerned when I had read that. However, the prosecutor did say that he had spoken with both mother's counsel and with substitute counsel. He said that on the record. And then substitute counsel said yes, that he was not instructed to object to a proffer. I think that covers that basis.
So sort of piggybacking on your exchange with Justice Standridge, it strikes me that one option the court may have is to just ignore the constitutional dimensions of this and just purely as a question of what is substantial competent evidence, say that a proffer by itself is never substantial competent evidence. I understand that directly contradicts the seeming purpose of the statute. But isn't that true, that a proffer can never be substantial competent evidence? For all these reasons we've discussed.
Justice Stiegel, I think that at times it could be evidence. Maybe this court will take the direction that it's a different type of evidence, but I do think that it can be evidence because the court is still bound by its same standard, the clear and convincing evidence. It still has to apply it to the statutes for unfitness.
Right, you're not arguing that the court gets to sidestep clear and convincing. So this case could have been appealed. I mean, it was kind of brought up on different grounds, but in some ways, a much simpler ground is just to ask, was there clear and convincing evidence?
And I think, Justice Stiegel, that there was the proffer. It was
Yeah,
very.
you have to, the state cannot prevail in this case unless the proffer is evidence. Correct?
I think that that's possible, Justice Stiegel, but
Well,
I do think that I do think that it.
How can you prevail? How can the state prevail if the proffer is not evidence?
Again, I
Then
would.
you have nothing, right?
I think, Justice Stiegel, I would go back and look at it through the lens of due process. The mother had the opportunity in multiple different ways to participate in this case.
Well, the state can lose termination hearings without violating the parent's constitutional right, correct? And again, that's a bit of a red herring when we're just talking about, was there sufficient evidence?
That is correct, Justice Stiegel. I do think it is also important that the record shows that the mother was served the motion for termination of parental rights. She also would have had notice of what it was the state's evidence was that they were planning on presenting. I would go back, Judge, to due process, and I think that the state can prevail on that and also the plain language of the statute.
But the proffer has to be clear and convincing evidence for the termination itself, which means if we view this, any proffer as evidence, it has to clear that threshold in order to terminate a parent's rights, correct?
I agree with that, Justice Wall. I think that the proffer, it should be on the side of caution, should be extensive, should clear and convincingly show the district court how this proffer of evidence meets the different prongs for unfitness.
So
So
essentially,
the adequacy of a proffer can always be challenged, really just under that clear and convincing standard, right? It really, I think as others have pointed out, maybe isn't, we don't even have to delve into the due process question, but just look at the quality of the proffer itself.
I would agree, Justice Wall, that it could be challenged. I don't think in this case, I think that the prosecutor was very extensive. GAL also chimed in, but yes, I do agree that if it were very short, if it were very terse, that it could be challenged.
And that's the problem, is the statute doesn't tell us what a proffer is. There's no standards imposed on a proffer. Is there, so basically what you're suggesting is that we go to the proffer itself and look for its reliability, which some states do in different circumstances, but we don't have that here. I mean, basically what you're telling us, look at the proffer, see if it's reliable, essentially.
Justice Rosen, I think there would be 3 different steps, just like in this case, have to go to the statute first, see if the parent actually objected, have to look at the parent's due process rights, if they received notice, if they had an opportunity, and then finally have to actually look at the proffer itself and make sure, okay, was it terse, was it vague? Did the parties who were speaking, did they clearly set out under what specific unfitness statutes and foreseeability statute? Was there enough to clearly tell the court why they should make those findings? And then I would also say, oh, I'm out of time, so I would say any other absent questions, I'd respectfully ask this court to affirm unless there's any other questions.
I can see them. Thank
Yes.
you. Mr. Klein?
I'm not going to jump up and down about my constitutional argument again. I think I've made my points there. I will say again.
Well, let me ask you on that question is, Justice Stiegel asked the same question, is under certain circumstances, the proffer can count as evidence, and can the legislature dictate to a court what is evidence and what meets clear and convincing standards?
I think the legislator can, but I don't think the legislator has, which is part of the problem in these cases. Again, the next part of the code after saying you can proffer evidence is that you have to follow the rules, the civil rules of evidence.
So do you think 2248F is ambiguous?
Ambiguous would be a kind word to use.
So you do. You do think it's.
Yes, it makes no sense.
So given that, and I know opposing counsel argued it was plain language in the state's favor. You've said it's ambiguous. If this is ambiguous, how should we go about construing legislative intent? And it seems to me that almost as a matter of logic, the only thing they could have intended by this language is for courts to consider proffers as evidence. And why else write this statute? Nobody thinks you can terminate rights with no evidence.
Well, some district courts have thought that. Again, there have been 3 default judgments in the last 5 years or 6 years. So some district courts have.
Well, that's a
separate.
That's a different issue. I'm trying to get you to articulate how you would have us construe this ambiguous statute.
The intent of this statute is to make the state's job easier. That was the intent of the statute. It was to make these cases go more quickly.
By allowing proffers to be counted as evidence.
By allowing proffers to be counted as evidence. That's the reason.
So you arrive at the same ultimate conclusion about the meaning of this statute as the state does.
Likely.
Okay.
On what do you base that legislative intent?
There's nothing in the record. That's the intent. That's my view of it. And based on my experience of doing this kind of law for a while and discussing it with people who helped write that statute, that part of the statute, that's where I come up with it. And again, that's my likely also my cynical view as well. There are other potentially valid reasons for it. I'll finish with this. At a minimum, the district courts, and the attorneys who practice in this area of the law need some guidance. I don't think we should abuse proffers. I don't. To me, it's shocking to the conscience, frankly, for all kinds of reasons. Mainly all constitutional. But if we look at the cases,
What would have happened if they put on evidence in this case?
same result.
How do you know?
And maybe not right. But I guess that's
Her attorney could have cross-examined and brought up things. We don't know.
yes.
But the same opportunity was provided to challenge the factual basis of the proffer that was provided.
I mean, if you're asking about dueling proffers, should the state proffer evidence and then, the mother's counsel here proffer evidence that's potentially different and then puts it at conflict and then district court has to decide which attorney is more credible? Is that what we don't want that. When I say it would have been the same result, what I'm saying is if the state had put on evidence that day without the mother present and with potentially with substitute counsel who had done no preparation, the result would have been the same, I think. I mean, there wouldn't, if there'd been a full evidentiary hearing with the mother present and mother's counsel present who had prepared, it could have been a different outcome.
And it was set for an evidentiary hearing, right?
It was set for a full day evidentiary hearing. And I'll just, I noted a number of cases that have showed kind of the problems with the proffer statute. There was a case that the Court of Appeals reversed where there've been a number of, there have been at least 3 default judgments. I mentioned those. They're in the last 6 years. In 2017, there was a case reversed because the proffer of evidence was characterized as a free-form discussion among the lawyers. That was quoting the Court of Appeals. And then there was a case that was reversed because no evidence at all was presented that would allow for clear and convincing evidence to be found in a case. And I'll leave it at that. There are issues with the statute. As you all know, for a case to go to the Court of Appeals, you have to find a parent and have a parent sign verifications 3 times. So imagine the cases where you couldn't find a parent and you couldn't get it to the Court of Appeals. So there are 5 cases I've talked about. That number is exponentially larger in the state with issues with proffers because those parents couldn't be found and you couldn't get the verification signed. And I'll leave on that. I think there's a problem with this statute. And I'd ask you to help fix it. And I'd also ask you to reverse the district court in this case. Thank you.
Thank you. Thank you to both counsel in this case. We will take the matter under advisement.